Number 1. If any person having sufficient means neglects or refuses to maintain A. His wife unable to maintain herself, or B. His legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or C. His legitimate or illegitimate child, not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury unable to maintain itself, or D. His father or mother unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate not exceeding 500 rupees in the whole as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct, provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of sufficient means. Explanation. For the purposes of this chapter, A. Minor means a person who, under the provisions of the Indian Majority Act 1875, is deemed not to have attained his majority. B. Wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. Number 2. Such allowance shall be payable from the date of the order, or if so ordered, from the date of the application for maintenance. Number 3. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issued a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowances remaining unpaid after the execution of the warrant to imprisonment for a term which may extend to 1 month or until payment if sooner made. Provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. Provided further that if such person offers to maintain his wife on condition of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer, if he is satisfied that there is just ground for so doing. Explanation. If a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. Number 4. No wife shall be entitled to receive an allowance from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. Number 5. On proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. But in order to claim maintenance under section 125, the woman should be legally wedded wife under the law applicable to her, as it was held in the case of Yamuna Bai versus Anant Roy. A woman who wants to agitate her right of maintenance can do so either under this section or by raising the claim before the civil court. The proceedings under section 125 cannot be allowed if the civil suit for the same purpose is pending before the civil court. The court in Ravinder versus Shaila Karmakar held that the decision of the civil court will prevail over the section 125.